quite radically in the case of the vast majority of Irish companies. Private companies limited by shares will no longer have objects clauses, and therefore the doctrine of ultra vires will not apply to those companies. And if they act outside of those objects, then their acts will be unenforceable. However, when dealing with such companies, particularly in the context of bank finance, a lender would be extremely well advised to have its lawyers look at the articles of association of those companies to ensure that any restrictions on the directors' abilities to borrow are not exceeded. Not quite. It's abolished in the context of private companies limited by shares, but it still has significance for other types of vehicles. So, for example, designated activity companies, which are new creations of the Act, will continue to have objects clauses which need to be reviewed, and their activities will need to be consistent with those objects clauses. The same applies for other types of entities, such as guarantee companies, PLCs, and unlimited companies. However, for the first time, there is in the Act a provision whereby the shareholders can retrospectively approve ultra vires acts by those entities. Not really. Irish companies are still obliged to have seals, and the seal must only be affixed with the approval of a board meeting or a meeting of a committee of directors. However, the Act has introduced a little bit more flexibility in relation to the identities of the person who can witness the affixing of the seal. So for the first time, it is not necessarily the case that a director needs to witness the affixation of the seal. No, not at all. When taking security over shares, a lender's counsel will need to review the Articles of Association of the company to examine whether the veto is contained in the Articles of Association. And if the directors do retain the ability to refuse to register a transfer, then the bank would be extremely well advised to ensure that it is removed. And that can be done by virtue of the passing of a special resolution of the shareholders. Yes, they will. The Act prohibits the giving of financial assistance by an Irish company for the purpose of the acquisition of shares in itself or in any of its holding companies. While there have been some refinements with the new legislation, the broad prohibition still remains. Certain of the refinements include certain favourable aspects. So the reference to the financial assistance being in connection with the acquisition of shares has now been removed, which is welcomed given the wide nature of that terminology. Equally, certain exceptions have been tidied up. So the refinancing exception, which was contained in the previous Act, has now been refined so that guarantees which are given on the refinancing, provided the original guarantees have been subject to a previous validation procedure, will no longer need to be whitewashed. Yes, you do. Irish companies are still obliged to file when they create security. And if they create charges or mortgages over any class of assets, then they are obliged to submit particulars within the prescribed timeframes. The exclusions to this relate to certain asset classes, including shares, cash, and accounts. The novelty in the new Act is that for the first time it gives you an option in relation to the registration process. You can continue to file particulars within 21 days of creation, but the alternative now, and in order to protect priority, the lender is permitted to avail of a two-step process. The first part of that process would entail giving the company's registration office advance notice of the creation of the charge, and then following the creation of the charge with a subsequent filing.